Now I will welcome Emma Lees, Professor of Environmental and Property Law at University of Cambridge. And you will walk us through what does the EU nature restoration law mean for biodiversity in Europe. Thank you so much.
Thank you. Okay, good morning, everybody. Thank you very much, first of all, to the organisers for inviting me to speak today. It's a really great pleasure to be here with you to discuss the EU's new nature restoration law. So firstly, I'd like to thank also the funders of this project. So this research was funded by the Otto, and bear with me for my Danish pronunciation of the next word, Mønsters Fund. And the work was done in collaboration also with Professor Oda Pedersen at the University of Aarhus. So in my talk today, I am going to cover three main parts. In the first one, I'm going to talk you through the member state obligations that emerge from the nature restoration law. And in the interest of time, that's going to be quite a quick explanation of the member state obligations, which means summarizing what is a very dense and lengthy piece of legislation into some core principles, which I hope will be useful. In the second part, I will then cover three puzzles that I think will emerge, or that we think will emerge from that law for the member states in terms of how they begin to operationalize and implement action with a view to meeting those obligations. And then in the third part, which is my conclusions, I'm going to just reflect on what this means about how responsibility for biodiversity preservation is allocated as between the member states or the institutions of the European Union. Because it is, in our opinion, it is how that balance is struck is really going to determine the ways and means of the operationalization of the nature restoration law. So let's start off with the obligations. In the regulation, these obligations come in two forms. There are substantive obligations and there are procedural obligations. The substantive obligations tell member states what they must achieve, and the procedural obligations tell the member states what steps they must take in order to demonstrate that they are going to achieve those outcomes. It's a mandatory methodology, which is built around member states drafting plans that explain how they're going to achieve the substantive obligations in the regulation. The obligations are many and various and broken down into lots of small parts, but there is one or a few sort of guiding principles, guiding targets, which underpin each of these obligations. So the obligation or the substantive targets, amongst others, are eventually to bring at least 90% of all listed habitat types into a good condition so that they reach a favourable reference area, meaning that their long-term viability is assured within effectively their natural range. And I'll come back to that idea a little bit later. There's also an obligation for an increasing and improving trend in relation to the quality and quantity of all sites, habitat sites for all protected birds and other species under the Habitats and Wild Birds Directive. Neither of these are time-bound obligations, right? The obligations do have specific dates associated with them, but the reaching of those targets does not, in recognition of the fact that natural processes and their timeliness is unpredictable. There are other eventual targets, including protection and enhancement of specific ecosystems, agricultural, urban, and river systems, for example. However, the main target relating to the restoration and re-establishment of habitats is what I'm going to concentrate on today. So, how do the member states have to go about attempting to achieve this target? There are 6 what we've called milestone obligations within the regulation. So we've given them these labels. These are not the labels in the regulation. There's nothing so helpful in the regulation as labels, but this is to help us kind of understand what's going on. So the 6 obligations are, firstly, the habitats improvement obligation. So this is that member states need to put in place restoration measures to bring what is currently not in good condition into good condition. Okay, so they have to improve the quality of those habitats. The second is a re-establishment obligation. And this is a little bit more complicated, because this is an obligation to turn what is not currently a particular habitat type into a particular habitat type, to restore what has been lost. And that has to be done by reference to natural range and to historical data. And I'm going to come back to why that might be difficult for member states in a minute. The third obligation is species-specific habitats obligation. So this relates to the habitats that are supporting protected species. The first one is habitats themselves. The third one focuses not on the habitat, but on the species. There's going to be a lot of overlap, but it's two different questions. And for that third one, member states have to ensure that there is sufficient quantity and quality, taking account of connectivity between spaces. As Martin was mentioning, that's very crucial. The fourth obligation is a continuous improvement obligation. What this means is that once member states have put measures in place, they have to make sure that the quality is going up. They can't put measures in place, all done, thank you, sit on their hands. They have to keep pushing forward, continuous improvement. The flip side of that is the fifth obligation, the non-deterioration obligation. This requires that member states, once the protected site has reached good condition, put measures in place to make sure that it doesn't go back underneath that threshold again. And then the sixth, which is just sneaked in at the end, is the one that I think is the most interesting. So this is a preemptive obligation. And what this means is that member states are required, by the time they draft their plans, which is in a very short window, to have put in place in relation to all sites which might be relevant for meeting their targets, measures that prevent further deterioration immediately. Why? Because otherwise the plan will be out of date. So if you make a plan and everything gets a lot worse before you get to do anything, your plan is pointless. So simultaneous with the creation of the plan also needs to go in place immediate protection measures to stop things getting worse across the totality of the potentially relevant sites, not just the smaller subsection that you might be focusing on for 2030. And that, I think, is potentially very significant. So this is a lot, right? The regulation was very controversial, as you may be aware, in its passage to legislation. There were a number of member states that did not want this to come into law. There were significant protests in member states, the Netherlands in particular. What we have is a watered-down version of what was originally proposed, but I think it's watered down. It is watered down, but it's still a lot, right? And it's not immediately obvious that member states are completely on top of what they've got to do in order to meet these requirements. I've put that very politely. So I don't want to bombard you with the legal detail on these obligations, and there is a lot. But what I thought would be useful would be to think about what is the relative kind of tricky parts that exists in this regulation, and there are three. The first is, in reality, you need to make choices and have priorities. The regulation doesn't provide any mechanism by which member states are to decide what those priorities are. It gives discretion for them to decide, but not guidance about how to decide. And these obligations, although they look nice on my previous slide, they don't sit comfortably together entirely. Particularly something like the re-establishment obligation. A re-establishment of a particular kind of habitat may have a detrimental effect on a protected species nearby, right? I don't know, turn something where little mice live into something where some other creature lives. They're not necessarily compatible. You can see I'm not a scientist. So how member states prioritize between their obligations is not obvious. And that question of who gets to decide what was an appropriate prioritization is also unclear, as I'll come back to. The second puzzle is the re-establishment obligation. What does it mean? And in particular, how far back do you go? And do member states get to decide how far back you go. So I'm from the UK, so obviously we don't have to do any of this. We can just let things fall apart quietly. But if you think about the east coast of the UK used to be almost completely wet and is now almost completely dry, how far back in history are you assessing what you re-wet? So there's a lot of discussion in the regulation about the re-wetting of peatlands, for example. Well, what are we talking about? Are we talking about prehistory or 50 years ago? Because those are two very different maps of Europe. The Commission gave, in its initial proposal, said 70 years, but that's in sort of biological terms very short and may not quite align with what is expected in terms of what the re-establishment obligation is intended to achieve. So how far back you go and who decides how far back you go and whether member states have flexibility to pick different time frames as amongst themselves is not clear. And there's not very much time for member states to find a solution to that. The final puzzle is how climate affects biodiversity preservation. In the regulation, member states will not breach the obligations if habitat deterioration is a result of climate change. And as you can imagine, a lot of coming habitat deterioration is going to be a result of climate change. How far a defence, it's not quite a defence, but that was a very lawyer's comment. How far that goes is very unclear. Two questions. Firstly, what happens where the deterioration is caused by climate change and something else? For example, rising sea levels, but a failure to put in place appropriate barriers. I don't know. Okay, does that count? Is it purely caused by climate change? No. Is it caused by climate change? Yes. The second puzzle relates to what happens when a member state tries to rely on this defence but isn't meeting its own climate targets. Right? It's generally a principle of law that you're not allowed to rely on your breach of one law to justify you breaching another, right? Which makes sense. When you have member states who are not achieving appropriate steps in relation to climate mitigation, adaptation, or climate change prevention, are they able still to rely on that to get out of biodiversity loss obligations as well? That's also not clear. So, I'm not too sure how I'm doing for time, but I'm going to move on to my conclusions anyway. Okay, so just to wrap things up, the consequence of all of this is that, thank you, 1 minute, is who decides is going to matter. Who decides the answer to those puzzles, the precise scope of those obligations is going to be very important. Do we leave it to member states who have on-the-ground realities in front of them, or is it left to the union institutions to supervise the activities of 27 member states? Not sure, okay? So one way that was attempted to resolve this is through focusing on the plan, right? The Commission's going to supervise the national plan. So that puts a lot of weight into the plan, but whether and how plans will be properly assessed for their adequacy is also not entirely clear at the moment. And then, as always with biodiversity protection, we come back to the puzzle of enforcement. Who is going to enforce and how and with what money? So, again, not very optimistic, but that was a kind of canter through the nature restoration law and explaining what it achieves. Thank you very much for listening and have a good afternoon.